I'm pleased to convene the first hearing of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties for the 117th Congress. I look forward to once again working with the gentleman from Louisiana, Ranking Member Mike Johnson, and other members of our subcommittee on the many challenging and pressing issues that will be addressing us in the months and years to come. While we will no doubt have sharp disagreements from time to time, it is my hope that we'll always be able to disagree within the guardrails of mutual respect as colleagues. Each of us was sent here to represent our constituents faithfully and to the best of our abilities. We begin this Congress by picking up on a topic that we devoted 2 hearings to in the previous Congress, which is the proper scope and use of the president's constitutional power to grant clemency. The clemency power is outlined in Article 2, Section 2 of the Constitution, and is rightly broad. Clemency power purpose is to act as a safety valve for our criminal justice system, to correct system injustices, and to ensure that mercy tempers excessively harsh punishments. There are a few things that more fiercely urgent than the need to grant clemency to the thousands who suffer from the burdens of excessive and unjust imprisonment or the collateral consequences stemming from their criminal convictions. Perhaps not coincidentally, these burdens are disproportionately borne by people of color. I have long been concerned with the stinginess with which modern presidents have granted clemency, beginning in the 1980s with the so-called war on drugs, which really goes back to the 1970s. Between 2013 and 2014, I wrote 4 letters to then President Obama and then Attorney General Holder, urging the President and the Attorney General to become more involved, to grant more clemency petitions. And I authored 2 opinion pieces on the subject calling for more clemency grants. In fact, I had written the President early in his second term and told him I had 3 C's I wanted him to work on: Cuba, cannabis, and commutations. It was alliterative, maybe somewhat effective, but he was a little shy on clemency. I also wrote to President Trump to commend him for commuting the sentence of Alice Marie Johnson and to encourage him to do more than his predecessor, who did issue a great number of clemencies, probably the most of anybody in recent time, but far from the amount of people that deserve them. And I asked him if he would do more in granting clemency to many cases like that of Ms. Johnson. It is my hope that President Biden will be a leading example of how clemency power could be more effectively used, especially among those who may be more deserving, but whose pleas have not been heard. The subcommittee will commit itself to pushing for more expansive use of the clemency power, an effort that I hope will be bipartisan, because we're talking about freedom, and we know both caucuses appreciate freedom. When considering what is the proper scope and use of the clemency power, however, there is another matter to consider, which is whether there are or should be limits on the power when a president grants clemency for self-serving or corrupt purposes, rather than as an act of mercy. Presidents of both parties have issued controversial pardons that raise these kind of questions, which is why they have been long-standing interest of this subcommittee. Such pardons are often not in keeping with the purpose of the clemency power. In 2019, the subcommittee considered the question of whether a president could issue a self-pardon, and the consensus among all of the witnesses at that hearing, including the one requested by the minority, was that on balance, the Constitution likely would prohibit self-pardons. Indeed, during the Nixon administration, the Department of Justice's Office of Legal Counsel concluded that self-pardons would be unconstitutional because of the basic principle that no one should be a judge of his or her own case. Questions about the proper scope of the clemency power took on greater urgency during the recent presidency. No president is permitted to abuse the power of his office to obstruct a law enforcement investigation, yet the manner in which President Trump used the clemency power throughout his presidency raised the concern that he may have been willing to do just that to protect himself and his political allies. For example, during the investigation of the special counsel Robert Mueller into possible Russian interference in the 2016 presidential election, President Trump on multiple occasions dangled the possibility of pardons for witnesses who refused to cooperate. Specifically, Paul Manafort, his former campaign chairman, Michael Flynn, his national security advisor, and Roger Stone, a senior campaign advisor. Ultimately, he would pardon all 3 of these individuals after their convictions for various criminal offenses stemming from the Mueller investigation during his final weeks in office. In addition to matters related to the Mueller investigation, President Trump used the clemency power in other potentially self-serving ways, as most of those who received clemency had some kind of special access or other political or personal connection to him. That seemed to be the thread rather than the crime and the sentence. This included clemency for 4 former Republican members of Congress, one of whom I was personally close to. Nevertheless, they had been convicted of various criminal offenses ranging from bribery and insider trading to misuse of campaign donations. Charles Kushner, his son-in-law's father, and his former chief political strategist, Steve Bannon, who was awaiting trial on fraud charges relating to a scheme to fund a wall on the U.S.-Mexican border, were also pardoned. President Trump also reportedly discussed pardoning himself and his children during his final days in office. We presume he didn't do that, but we don't know that for a fact because there is such a thing as a secret pardon, which is something we should address today. In light of the foregoing, I introduced H.J. Res. 4, a proposed constitutional amendment that would expressly prohibit presidents from granting clemency to themselves, prohibit clemency grants to certain classes of people like the president's family members to the 3rd degree, administration officials, paid campaign staff, or any person or entity who committed an offense directed by the president. It also has a catch-all provision making any pardon invalid, which was issued for a corrupt purpose. I'd introduced similar resolutions in the previous 2 Congresses. While this proposed amendment precludes clemency for certain potential recipients, I would also like to talk about ways to improve the clemency process, transparency, and the timing of pardons and commutations. Specifically, I would like to hear the witnesses' views about requiring public notice of pardons to get around the issue of a possible secret pardon, or commutations that might be issued before Election Day. I think Mr. Foley had suggested some type of prohibition before Election Day, but it would have, or after the election, but it would have to have some time period and a requirement of notice for if there was a secret pardon, it wouldn't be known. That would have to be addressed. So public notice of pardons or commutations, maybe a time before Election Day so that voters have notice, not only in a presidential, obviously in a presidential election year and probably only in the first term. Requiring more transparency to avoid secret pardons and revising the system by which clemency decisions are made, including removing or curtailing or otherwise amending the role of the Department of Justice with respect to the clemency process. This will not be our last look at the clemency power in this Congress, as the subcommittee will continue to engage on this issue, including from a criminal justice reform perspective. I thank our witnesses for being here, and I look forward to a lively discussion.